So everybody should see a little notification there. If you just hit accept, then that'll move us forward, and I'll hand it over to Jenny.
Thank you, Mark. Hello, everyone. Welcome, and thank you for joining. So thank you, the Center for Latin American Studies at Ohio State, for this event's idea and collaboration to making it happen. And thank you, Bruno, the speaker today. I'm Jane, director at the Ohio State Brazil Gateway. The office is located in São Paulo. So if any of you visit Brazil, São Paulo in the future, let us know. Maybe you can visit our office now. The pandemic restrictions are over. And so if you're asking, what are the Ohio State gateways? Well, along with the China and the India gateway, we are the global gateway. So there are 3 offices. And our missions include connecting Ohio State community with partners and opportunities here in Brazil. And some of these also include highlighting the work of current Buckeyes, which is Bruno's case. He is currently a visiting scholar at Ohio State doing research. So we wanted to highlight what he's been doing. But I wanted to give you a very quick overview of other things we do, just in case something happens and you can think, oh, I should reach out to Jane. So we're working 4 key areas. Students is one of them, where we help Brazilians interested in pursuing undergraduate, graduate, and professional education, and also research at Ohio State with information on how to apply. We also help Ohio State current students come to Brazil for education abroad experiences, research, and internships. We also try to keep the alumni together. Yes, the Brazilian Buckeye family connected here and supporting and helping each other. We also work with research. So we try to connect to Ohio State faculty and Brazilian institutions so they can collaborate, apply for grants, publish together, for example. And the last of our areas of focus is partnerships, where we connect Ohio State not only with universities, but also with companies, government offices, and nonprofits, so that we can host events together. They can offer internships for Ohio State students. So yeah, that's a quick overview. I will share with you on the chat our website page and our social media, email, so you can learn a little bit more and reach out if you have interest. We also have a bi-monthly newsletter that you can register to receive. So yeah, that's it. Back to Mark, who will introduce Bruno a bit better.
Thanks, Jane. Yeah, so today we have with us Bruno Cunha. Thanks for joining us, Bruno, and for offering your time and your expertise today. Bruno is a city attorney in Recife, Brazil, so in the Northeast, and a professor of law. He's also currently a visiting scholar at the Ohio State Moritz College of Law under the mentorship of Dr. Stephen Hefner, professor in law and judicial administration, who I believe is here with us today. So thanks for joining, Dr. Hefner. As part of the Visiting Research Scholars Program, Bruno is taking advantage of the library resources here at OSU in order to read and separate materials for his PhD thesis through the Federal University of Pernambuco. Bruno's research focuses on the use of foreign precedents in constitutional adjudication by the Brazilian Supreme Court, with a focus on US Supreme Court precedents, and that will be a large part of his talk today. He plans to audit classes at Moritz, and I think is maybe even doing that now, and in the history and political science departments here at Ohio State, so sort of taking advantage of everything that campus has to offer. Bruno holds 2 LLMs from the University of São Paulo in 2014 and the University of Michigan in 2017, and he's finalizing the organization of a book to be launched hopefully next March, I believe it is, at the University of Texas, together with Richard Albert and Brazilian Supreme Court Justice Luis Roberto Barroso. And next March, when that takes place, there will be a summit on constitutional law that Bruno will be a part of. Bruno is also working on translating a book from 1912 on the US Constitutional Convention into Portuguese. So In addition to the things Bruno's going to talk about specifically today, feel free to ask questions about any of those other elements, because I know Bruno is always excited to talk about his work. So without any further ado, I'll hand it over to you, Bruno, to present your talk entitled Judicial Dialogue, the United States Supreme Court and the Federal Supreme Court of Brazil, a Historical and Comparative Analysis.
Thank you very much, Mark. Thank you, Jane, for introducing me. Thank you guys for having me here today. It's an honor to be here. And thank you, Professor Huffner, to be here as well. The idea of my talk today, first of all, I want to thank the OSU Center for Latin American Studies, the OSU Brazil Gateway, as Gianni is here, and the OSU Moritz College of Law for having me and for this opportunity to present my research subject and a little bit of my PhD thesis that I'm trying to write right now here in the US. So as an introduction, I want to just present a little bit myself, a little bit of an introduction. I am a PhD candidate at the Federal University of Pernambuco in Brazil. And my research subject there is the use of foreign law by the Federal Supreme Court of Brazil, with a focus on the use of US Supreme Court case law by the Brazilian Supreme Court. I am expected to finish that by 2025, so I still have plenty of time in my research, and I hope I finish by then. Just to explain a little bit why I chose this topic, the start of everything, as I say, after I finished my master's in Brazil in 2014 at the University of São Paulo, I came here to the US for an LLM at the University of Michigan Law School. I know that we are here at OSU, sometimes it's hard to say that name, the school up north. But I went to Michigan as well. I can say that I am a Michigan fan and an OSU fan, which is quite hard here in the US. But when I went to my LLM there, I focused on learning as much as I could about US history, the Supreme Court history, and constitutional law, US constitutional law in general. And this led me to seek or to gain a deeper knowledge on the following themes: US-Brazil relations throughout history in general terms, the influence of US political and legal scenario abroad, specifically in Brazil, of course, and how Brazil used the US model, the US constitutional model and legal model for its own institutions, courts, and administration. So my PhD subject, in a nutshell, is the judicial dialogue between Brazil and the US, the use of US Supreme Court precedents by our Supreme Court in Brazil. And there are 2 points that are worth mentioning in my subject, within my subject: the legal scenario and the historical scenario. And that's what I want to present for you today. So what is the legal scenario underlying my research? That's what we call the globalization of constitutional law, or a new wave of common core constitutional ideas all around the world. So we have, what kind of tool we have to study that? We have today what we call comparative constitutional law, quite recent, which is quite recent as an autonomous discipline within the legal field. And it started to rise with the rise of liberal democracies after the world wars, pretty much after 1945, and with the fall of the Berlin Wall in 1989. So at that time, we had the enactment of several new constitutions throughout the world, and what we call a new wave of global constitutionalism. So the discipline, comparative constitutional law, gained momentum at that time and in these last decades, and fostered a vigorous debate, academic debate all around. For this discipline, for comparative constitutional law, we can say that we have like 2 basic uses as a legal tool. The first use of comparative constitutional law is in the constitutional making processes for the newly created constitutional regimes or countries. And we tend to look abroad to set up a new constitutional regime. So that's why comparative constitutional law is really useful as a legal tool in that kind, in the constitutional making processes all around the world. So, for example, looking for constitutional structures and features such as federalism, separation of powers, and etc. And the second great use that we have for comparative constitutional law as a legal tool is the idea of constitutional adjudication practice of courts, or specifically constitutional courts, to refer to the law of legal systems other than their own as a legal argument. That's what we call comparative reasoning in constitutional law or in constitutional adjudication, or straight to the point, the use of foreign law or foreign precedents within constitutional adjudication. That's what I'm planning to study in my PhD, and that's what I'm planning to talk a little bit today for you guys. So lots of discussions will arise when we talk about that. Mainly the problem of cherry picking, which is a legal term to say that we have a problem when choosing, for example, what kind of precedents or what kind of foreign law to cite, which countries to cite, for example. The lack of methodology is another problem. We don't have like a really good and established methodology in the use of foreign precedents all around the world. We are still trying to build that methodology right now in the legal academia. And even the whole idea of a global constitutional convergence or global constitutionalism, as some scholars call, is still in doubt that this really exists or not. So that's what I'm trying to study as well within my PhD. So in Brazil, the use of foreign law or the foreign precedents is on the rise just like elsewhere. So all around the world, this is on the rise. This recent idea of a global community of courts or common constitutional identity throughout countries is trending more than ever. So academics from all around the world are engaged in discussions like that. When it comes to my thesis question, I can say like straight to the point, that is to understand how and why the US Supreme Court is seen or can be seen in the case of Brazil as a major influence for the Brazilian Supreme Court in terms of constitutional adjudication, in terms of comparative constitutional reasoning. So in search for an accurate answer for that, we must address two topics. First, how the constitutional or the state structure brought by the US Constitution influenced the Brazilian Constitution or the Brazilian state structure throughout history, and how and why the Brazilian Supreme Court relies on US Supreme Court case law to decide cases under the Brazilian Constitution. So we have to look for the legal foundations for the use of foreign precedents in Brazil. And what I'm trying to do here is to look, how does that work in Brazil and how does that work in the US? Because in many legal systems, the use of foreign precedents by courts lacks express regulation or authorization. And there is always a debate on whether courts can resort to foreign law when dealing with disputes arising domestically. So for example, if we look for the Constitution of South Africa, it's written on their constitution, the following phrase: when interpreting the Bill of Rights, a court, a tribunal, or a forum may consider foreign law. It's expressed there in their constitution. But what is the scenario in the US? There is no express regulation about that. And I can anticipate here the same in Brazil. We have no express regulation today about that, about the use of foreign law. So recently, the issue here in the US of the use of foreign law led to a great debate within Supreme Court justices. That's what we call the Scalia and Breyer and Kennedy debates here in the US Supreme Court. These debates are basically dealing with how the US Supreme Court deals with the use of foreign law. So there is a series of cases dealing with this issue in the last 15 to 20 years. And what is the basic trend here in the US? Progressives or liberals are much more in favor of the use of foreign law in constitutional adjudication, and conservatives on the other hand are much more against this use. And I can tell really fast here 4 cases in this last 20 to 25 years, something like that, that showed this problem within the US Supreme Court, and it comprises all the legal scenario in the US, of course, not only the Supreme Court. So in 1999, just for you to know, we had Knight versus Florida, a death penalty case, and the issue was whether almost 20 years on death row would be considered a cruel and unusual punishment under the 8th Amendment. And Justice Breyer, when was deciding that case, actually he was dissenting on the denial of certiorari on that case. He brought a lot of foreign cases in his decision. He brought cases from the European Court of Human Rights, the UK Privy Council, Supreme Courts of India and Zimbabwe. And Justice Thomas was outraged with Justice Bryan bringing cases from other countries. And he said the following phrase: "Indeed, were there any such support in our jurisprudence, in our own jurisprudence, it would be unnecessary for proponents of the claim to rely on the European Court of Human Rights, the Supreme Court of Zimbabwe, the Supreme Court of India, or the Privy Council." So we started to note at that time a clash between some justices on the use of foreign law. Breyer on that case was totally in favor of that, and the Justice Thomas, much more conservative, was against. 4 years later, on a classic on Lawrence v. Texas, a huge Supreme Court case that judged that sodomy laws were unconstitutional here in the U.S. Because they violate the right to privacy under the 14th Amendment. Justice Kennedy relied on foreign cases from the European Court of Human Rights when deciding. The case was Dudgeon versus United Kingdom from 1981. And just like Thomas on the Knight v. Florida case, Justice Scalia in this case from 2003 was really outraged. And he said that the court's discussion of these foreign views, ignoring, of course, the many countries that have retained criminal prohibitions on sodomy, is therefore meaningless dicta. Dangerous dicta, however, since, and now it's the point, this court, the Supreme Court, Justice Scalia said, should not impose foreign moods, fads, or fashions on Americans. So Justice Scalia was totally against the use of foreign law here in the Supreme Court on that case. The third case that I want to mention is Roper v. Simmons, a case from 2005, another death penalty case. The issue there was whether offenders who were under the age of 18 when their crimes were committed could be sentenced to death, but the Supreme Court found that it was unconstitutional. And Justice Kennedy, again, on that time, he was at that point the swing justice. That's one of his phrases on the judgment. He said that the opinion of the world community, while not controlling our outcome, does provide respected and significant confirmation for our own conclusions. So Justice Kennedy at that time used the idea of confirmation from the world community to the US Supreme Court decisions. And Justice Scalia, again, leading the opposition to for the use of foreign law in the Supreme Court, said the following: "Though the views of our own citizens are essentially irrelevant to the court's decision today, the views of other countries and the so-called international community take center stage." So Scalia, again, was outraged with the use of foreign law within the Supreme Court, and was like tackling the ideas of Kennedy when Kennedy talked about the world community and the idea of confirmation from the world community to what the Supreme Court decides. And 5 years later, that issue came out again. So it was a case about life imprisonment without parole for a non-homicide crime committed before the age of 18, which the Supreme Court found unconstitutional. And Kennedy again brought foreign law to that case. And he said that the judgment of the world's nations that a particular practice is inconsistent with basic principles of decency demonstrate that the court's rationale has respected the reasoning to support it. So Kennedy, at this time, he changed his idea, but he didn't use the idea of confirmation anymore, but he said that the idea of a respectable support from the world's nation would be a good judgment for the Supreme Court. So whenever we have this respectful support from foreign law, we are in a good way of judgment. Justice Thomas, at that time, again opposing the use of foreign law at the Supreme Court, said that the court's discussion of foreign laws and sentencing practices are totally irrelevant to the meaning of our Constitution or the court's discernment of any long-standing tradition in this nation. So we can see that the liberals with Kennedy here, the swing justice, are always in favor of the use of foreign law, while the conservatives here in the Supreme Court are always like opposing this use. And we have two more pieces, two articles that were published, and I really like these two articles that deal with this idea of the use of foreign law in the Supreme Court of the United States. The first one is a famous piece by Judge Richard Posner. It was published in 2004 at the Legal Affairs, And even the title is amazing, because Judge Posner said at that time, "No thanks, we already have our own laws. The court should never view a foreign legal decision as a precedent in any way." And at that time, Judge Posner said that there are three main problems in using foreign law here at the US Supreme Court. He said that there are promiscuous opportunities that are opened up to choose which countries or decisions to cite. Again, here we have the cherry picking problem of comparative constitutional law or the use of foreign law. Posner also said that these decisions, these foreign decisions, they emerge from a complex socio-historical, political, institutional background of which the American judges are almost entirely ignorant. So they don't know what they're citing. They don't know the background of those decisions that they're citing. And he also pointed to the undemocratic character of citing foreign decisions, because judges who decided those cases, they have no democratic legitimacy here in the US. It's a famous piece by Judge Posner. There are lots of criticism on that piece, but it's really an influential piece on the use of foreign law. And there's another one written by Emily Bazelon. It was in The Atlantic in 2004. And the title is also really nice because it says, "What would Zimbabwe do?" It's a joke with Justice Breyer, who used a foreign case from Zimbabwe once here at the US Supreme Court. And Emily Bazelon makes a great summary of the US Supreme Court debate on that issue, on the issue of foreign law, and concludes by saying that a victory for comparativism, which is using foreign legal rulings to help interpret the Constitution, could have conservative judges citing international precedents that support their own arguments. That's to say, laws that restrict abortion in Germany or in Ireland, or limit free speech in Canada, that would be the foreign law version of, if you can't beat them, then join them. Because whenever conservatives start to cite foreign law, of course, searching for legal decisions that they like, let's say, comparativism will gain even more momentum here in the US. But anyway, it looks like foreign law is still on the rise here at the Supreme Court of the United States. And there's, you can see here a cover of the book, of Justice Breyer's book, with a huge defense of the use of foreign law in the modern world and in the US Supreme Court. So what is the scenario now coming from the US and now arriving in scenario about foreign law in Brazil? To understand that, we need a little bit of history, and we need to know that after achieving its independence in 1822, the new empire of Brazil needed to break its political ties with Portugal. But instead of a monarchical republican transition, just like the US did in 1776 and 1787 with the Constitution, the monarchical regime was continued in Brazil with Pedro I, the new emperor, and the first constitution of Brazil in 1824 was still a monarchical constitution. So we didn't have such a transition just like the US did here in 1776 and 1787. And it was only in 1889 that Brazil transitioned from a monarchical to a republican regime, more than 130 years ago. And it's from that point, and it's from that transition that we can trace the increase of the American influence in Brazil. That's the point that most scholars point when they want to show where the American influence started to gain momentum in Brazil. But I have to go back a little bit. Even before the transition to a republican regime, we had Pedro II, emperor of Brazil between 1840 and 1889, who was an avid Americanist. He just loved the US. Pedro II was a vigorous sponsor of learning, culture, and the sciences. He was a man of sciences, a really intelligent man. And just as a curiosity, he was the first foreign head of state to ever visit the US. He came here to the US in 1876. Before him, actually, King Kalakaua from Hawaii visited the US in 1844, but Hawaii was later incorporated to the US, so I don't count that. So I can easily say that Pedro II was the first foreign head of state, the first foreign leader to ever visit the US. And Pedro II was amazed with what he saw in the US. He spent more than 3 months here traveling through the US. I'm going to show you that. And we can read today, he left his diaries for us, and we can read his diary and see how amazed he was with the US, with the institutions, with the progress of the country at that time in 1876. And the American people, on the other hand, we can read in the newspapers from the time, praised Pedro II for his intelligence, for his character, and for his manners. He was really praised here. I'm going to show here the map. He visited the US in 1876. He even crossed Ohio 3 or 4 times. He made a stop in Cincinnati. He didn't stop here in Columbus, but he was close here in Cincinnati. And we can see that from the office of the historian in the Department of State, I just pasted that. Emperor Pedro II visited the US from April 1876 until July. He covered more than 9,000 miles in the US. He went to San Francisco, New York, New Orleans, Boston. He visited Washington twice. He met with President Ulysses S. Grant at the time. He was at the opening of the Centennial Exposition in Philadelphia when the US was celebrating the 100th anniversary of the Declaration of Independence. And I'm telling you all that just to say that the idea of looking to the US as a mirror and as an influence, as an aspiration, was on the rise in Brazil even before we transitioned to a Republican regime in 1999. So I'm gonna turn back to 1889. We had this military coup here, military coup d'état, that overthrew the constitutional monarchy in Brazil, the empire of Brazil since 1824. The military coup d'etat overthrew Pedro II as well, and established the so-called First Brazilian Republic in 1899. And there was no doubt. The First Brazilian Republic had a newly created federal system, which was inspired, 100% inspired in the US. And that was because pretty much one man, Rui Barbosa, one of the prominent Brazilian lawyers and statesmen, he wrote the Federal Judiciary Act of 1890, already within the Federal Republic and this first Brazilian Republic. And he championed the idea, which is in Article 386 of this Federal Judiciary Act of 1890, that says that the statutes of educated nations, and especially those governing legal relations in the United States of America, the case of common law and equity will also be subsidiary to federal jurisprudence and law. So by the work of Rui Barbosa, Brazil had a law, Federal Decree 848 from 1890, the Federal Judiciary Act, that said that we could use foreign law, specifically foreign law from the US, as subsidiary to our federal jurisprudence. So by 1891 in Brazil, we had what I call the perfect storm, mainly under Rui Barbosa's ideas. So in terms of structure, constitutional and state structure, the 1891 Constitution was pretty much modeled under the US Constitution, and it followed most of basic principles from the US Constitution. We had a presidential republic, we had federalism, we have the regulation and separation of state and church relations, we had a Bill of Rights, separation of powers, a legislative branch with 2 branches, we had the Supreme Court, our Supreme Court model by the US Supreme Court with life tenure for justices and everything else. So in terms of structure and also in terms of constitutional reasoning, we were allowed to use foreign law and specifically US case law to judge our cases in Brazil under the Brazilian Constitution. So the following constitutions of Brazil in 1934, 37, 46, 67, 69, and even 88, our current constitution, they all maintained these structural provisions and kept alive the American influence on legal or institutional scenario. So just as a curiosity, we can see that the Empire of Brazil flag until 1889, there on the first flag that I show here. And then when we adopt our constitution in 1891, and when we had the Federal Decree 848, we adopted another flag, pretty much a copy of the U.S. flag, as you can see. It was our first Republican flag. And then I just put here our current national flag, which is totally different from the two other. But just to show you how strong was the influence of the American political scenario and legal scenario in Brazil. But turning to the point of my thesis here, how the Brazilian Supreme Court is dealing today with foreign law. Although we don't have anymore this federal decree, which was formally repealed in 1991, almost 100 years later, and we do not have an express authorization today in our law for the use of foreign law in our legal system, our Supreme Court uses foreign law in its decisions on a daily basis. Pretty much every day we can see our Supreme Court inciting cases from abroad. But unlike the Scalia and Breyer and Kennedy debates that I talked a little bit before, it looks like our Supreme Court in Brazil takes for granted the idea of citing and using foreign law. We can say that by noting almost no discussion at all within our Supreme Court about the use or the abuses of foreign law. But we have to mention here, and I have to mention here at least two cases in which there was some discussion. We had this really old case from 1964. It's a case about academic freedom during the military dictatorship in Brazil. And we have this famous justice in Brazil, Justice Victor Nunes Leal. When deciding this case about academic freedom in 1964, he cited a US Supreme Court case about the same issue. The case is called Sweezy versus New Hampshire, decided in 1957 by the US Supreme Court. And when he cited the case, it sparked the longest debate about the use of foreign law that we have in the Brazilian Supreme Court until today. So I just quoted here some phrases about this debate from 4 of our justices at that time. And then I'm going to read here because these 4 phrases are amazing to see how you were dealing at that time in 1964 with the use of foreign law in our Supreme Court in Brazil. So Justice Pedro Chaves, he said, "I always listen with great regret these invocations that you make about the US culture, which is absolutely different from our culture." And then Justice Victor Nunes Leal replied, "If I invoke an example of a more advanced country, it is so that it can serve as a model." And then Justice Gonçalves de Oliveira replied as well, "Model in some things, not in others. For example, in the case of class hatred, in the hatred of blacks, so much lack of humanity." So he was criticizing the US and say that we don't need to follow the US in any sense. And then Justice Hermes Lima replied again and said, "Does the cultural difference allow us to be sad in the United States with the lack of academic freedom and does not allow us to feel the same thing in Brazil? Does the cultural difference authorize the lack of academic freedom in Brazil?" So I brought this to trying to summarize that we at least at that in 1964 had a little bit of discussion about the use or abuse of foreign law within our Supreme Court. And as I said, that's one of the only cases that we can see that. And again, in 2003, 40 years later, we had a case in habeas corpus, a case about anti-Semitism, and lots of justices, I think 7 of the 11 justices of the time at that time, cited foreign law, and they cited lots of U.S. Supreme Court cases. And then Justice Moreira Alves, one of the justices at that time, he said the following: I want to make some considerations about the precepts collected in comparative law, having reservations regarding the interpretation of national law based on foreign law, since legal traditions, legal reasoning, and the legal system are closely linked to cultural aspects of a people. So he was kind of criticizing the abuse or the use of foreign law by lots of the justices at that time in Brazil. So just repeating, these are almost 2 of the only cases in our Supreme Court that we can see a little bit of debate on whether it's good or not, if it's possible or not to use foreign law in Brazil. So much more than questioning if we should keep using foreign precedents in our Supreme Court or stop with this practice. And my idea here is to understand the reality. I want to look to the reality. So in other words, since we are doing it a lot, and our Supreme Court is citing foreign cases on a daily basis, as I told you, I want to be practical, and I want to understand how we are doing that. So from this point, the idea of all my research is to track the following path: whether this historical background between Brazil and the US is somehow responsible for our Supreme Court predilection in the use of US Supreme Court precedents. Because I can affirm here, the US Supreme Court is the most cited court in Brazil, foreign court in Brazil. And the second point is how and why specific US Supreme Court cases are used in Brazil by our Supreme Court, and why justices in Brazil are relying more on US Supreme Court case law than cases from other jurisdictions. So in a nutshell, this historical argument of constitutional structure must be added to the legal argument of comparative reasoning that I talked before, in order to investigate how the US Supreme Court shaped constitutional adjudication in Brazil in the past, and it still shapes today. Because as I told you before, these are the main questions of my thesis. And to finish here, I just want to show this historical background, this legal background, and I want to show some data that I gathered thus far from our Supreme Court. So if we look for the data there, our federal Supreme Court, I chose this time frame from 2000 until 2023. I need to mention that our Supreme Court functions as a constitutional court, and it has also appellate jurisdiction. It judges more than 15,000 cases a year, which is massive compared to the US Supreme Court that judges something like 80 to 100 cases a year. But we have, from 2000 until today, at least 245 different US Supreme Court cases cited by our Supreme Court. And I brought here a list of the most cited cases in our Supreme Court. So you can see McCullough versus Maryland, Marbury versus Madison, like really famous cases, Miranda v. Arizona, Mappy v. Ohio, criminal procedure cases, Ex parte Milligan as well. So it's massive, as I told you. We are citing those cases a lot, and I even brought here just to have an idea how our justices are citing these cases. So we can see here that all Supreme Court justices in Brazil are citing US Supreme Court cases. We have some justices that are more affected to that. For example, Justice Celso de Mello, who he retired like 2 years ago. He is the champion on citing US Supreme Court cases, but all the justices are working with those cases, are citing those cases, are using foreign law, specific case law from the US to interpret the Brazilian Constitution. And just to finish, I'm here in 32 minutes. I think I'm on time. I just want to show this graph that I prepared for today. We can see the trend here. From 2000 until 2021, I still have to gather the data from last year, from 2022 in this graph, but you can see that it's on the rise. We are citing more and more. Our Supreme Court, the Brazilian Supreme Court, is citing more and more the US Supreme Court. And that's the main reason and main goal of my PhD, is to understand how and why we are doing that. If it's this historical background, if there's any legal hint to be found here to address to reach a better answer, let's say. But thus far, I don't know. I'm in the middle of my PhD. I still have like 2.5 years more, and when I finish, I'm pretty sure that I'll try to have an answer for you guys. So I think that's it. I want to thank you again, everyone that's here listening to me. I want to thank OSU Brazil Gateway, the Center for Latin American Studies, the OSU Moritz College of Law for having me here, for giving this opportunity for me. And I want to thank Johnny, I want to thank Mark and Professor Höfner for listening as well. So I'm open to questions, to discussions, and thank you very much again.
Thank you so much, Bruno. This is fascinating. I have a couple questions, and maybe I'll start us off with just one. But I definitely encourage folks to raise their hand, and then I can just sort of call on you, and you can come off mute and ask your questions. So I'll just lead with this first one. Can you tell me if this is sort of a correct generalization, if I've understood correctly what you were describing, where it looks like, at least in the US, conservative justices have tended to, especially Scalia, for example, have tended to sort of reject the appeal to foreign law sort of wholesale, regardless of the nation in question, or maybe even regardless of the topic. Whereas it looks like on the Brazilian side, maybe there's a little more nuance. So could it be the case that the topic of the case at hand, also maybe which nation's court we're appealing to, is also a piece of it? It looks like there was some appeal to sort of a preference to the US or so-called advanced nations, or maybe nations that are culturally similar. Is that the case, that there's a little more consideration of context, whereas in the US, it's more of just a wholesale rejection of anything non-US?
Yeah, great question. Thanks, Mark. I have to say that in the US, we have this division, this ideological division in regards to foreign law. It's clear for everyone that the conservatives are rejecting more the idea of using foreign law at the Supreme Court level. But no levels here, no courts here in the US, you can see this division. But one thing that I want to add, and I think it's one of the answers to your question, is that in Brazil, we don't have this ideological division. All justices from all ideological backgrounds, they're all citing foreign law. Not only US foreign law or case law, but as you mentioned, we have lots of justices citing the Federal Constitutional Tribunal of Germany. And there's one point I want to add a parenthesis here, that sometimes we have, for example, we have two justices in our current Supreme Court that they studied here in the US. For example, Justice Ricardo Lewandowski and Justice Barroso, they both came here to the US for an LLM, just like I did. So of course, they know the country, they know the legal system much more than the others. So it's easier for them to cite foreign law from the US. And on the other hand, we have Justice Gilmar Mendes in Brazil. He went to Germany for his PhD, and he's the champion of Germany foreign law in our Supreme Court. So, but straight to the point, I have to answer you. The main difference that I see is that in the US, we have this ideological division in regards to foreign law. Conservatives are against that, and liberals are praising that. Whereas in Brazil, we don't have it. Everyone is kind of looking abroad. It's much more a trend in all ideological divisions in Brazil. We are looking abroad, so it doesn't mind if we're looking to the US, to Germany, to Italy, even to South America. Sometimes we are looking to Argentina, Colombia. We have some cases in Brazil that we are citing the Constitutional Court of Colombia, which are really famous cases in our Supreme Court. But we have this ideological division, and a little bit another thing that I want to add is this background of the justices, that it helps a lot when the justice has a background in the country. So, for example, Justice Barroso here in the US, he went to Yale Law School. Justice Lewandowski went to Tufts. In Boston, I think it's Tufts, and Justice Gilmar Mendes, who went to Germany for his PhD. And one question that I'm trying to scrutinize here in my PhD while I'm gathering this data is I'm trying to look if Justice Gilmar Mendes, for example, tends to cite more Germany or the US, because he went to Germany. And for example, if Justice Barroso is citing more the US than other countries because he came here to the US. But even the justices that didn't study abroad or have no contact with other jurisdictions, as I told you, they're citing case law from lots of countries. So in Brazil, we don't have the ideological division, but we have the idea that, in my opinion, of course, now it's my opinion, we are much more open in a general sense than you guys here in the US. And we don't have this huge opposition, just like Scalia says. Scalia, I really like to read Justice Scalia opinions. He's one of the smartest minds, legal minds in the US. Like him or not, he's a smart guy. He was a smart guy. And he has a phrase, I don't remember the phrase exactly, but he said once in an opinion that he would never look abroad to interpret the US Constitution. And he said like that, and he wrote like that. Justice Thomas did that as well. He said, any comments or any foreign views are irrelevant to the interpretation of the US Constitution. You would never see that in Brazil. In any of the justice regarding, and it doesn't matter which ideological background they have. So it's amazing to see these differences that you guys here in the US, you guys still have a debate on whether it's possible or not to resort to foreign law, whereas in Brazil, we don't have that. We never, it's a no question. It's totally a no question. No one discussed that, if it's valid or not. We're just citing foreign law and that's it, you know.
Thank you so much. Dr. Hefner, or is it Huffner or Hefner? Sorry, I'm guessing there, but feel free to come off mute.
Thanks, Mark. It's Huffner, but it's fine either way. I think Maria had her hand up first. Maybe.
Okay, Maria, would you like to come off mute and ask your question?
Yes, hi, can you guys hear me well?
Yep.
I have a question, and Bruno, I loved your presentation because I share this passion of making our two systems talk a little bit. I also have an LLM in the US, so I'm very passionate about it. But my question is, when we start citing foreign precedents, how can we ensure legal certainty? And maybe my question goes beyond the point here.
Yeah, I think your question goes straight to the point, because when you talk about the issue of cherry picking, for example, and I just want to go back here in my slides, because I agree with Judge Richard Posner on one of his criticisms about the use of foreign law is when he says that it's hard because we have promiscuous opportunities that are open to choose which countries to cite or which decisions to cite, and sometimes we don't know the background of those decisions. I think I told in the first slide I was talking about the lack of methodology that we have to cite foreign law, to use foreign law, or even comparative constitutional law. So it's hard to know if someone is citing a foreign case. For example, in our Supreme Court, we have a famous case in Brazil that Justice Barroso cited Roe v. Wade, cited Planned Parenthood v. Case, the abortion cases here in the US. But with all due respect, he didn't get right to the point. He wrote something, but there wasn't what Roe said, there wasn't what Planned Parenthood said. So we have this problem. And I think it's hard not to have this problem, because you need to study a lot the other culture, the background of the decision when you want to cite. So one of my propositions at the end, or at least I expect to have this at the end of my thesis, is to try to find at least a common core of methodological steps in order to cite foreign law in our Supreme Court in Brazil. Because what we have now is like what I call a carnival. We can cite whatever. We don't need to go deep on what we are citing. We just need to know, okay, Roe v. Wade, abortion. Oh, okay, no, we don't have Roe v. Wade anymore, so no citing of Roe v. Wade. We don't have like any rules for that. We don't have any methodological steps in order to cite well. So the lack of regulation, or I wouldn't say regulation, but the lack of methodology is a problem for us, because we don't know what we are doing much. That's and your question leads me to one of the main criticisms that scholars tend to say when they're talking about the use of foreign law, which is this idea that we need to understand better the other system, for example, the US system, in order to cite in our system, in order to use that kind of foreign case in our system. So I tend to say that we are very far, I would say, from solving this problem. I don't know if I answered you, but my answer would be, it's hard to cite foreign law when we have no methodological steps or we have no rules, any kind of rules, even informal rules to cite those precedents in our jurisdiction, for example, in Brazil.
Thank you so much.
Well, I'll jump in then. And Bruno, thank you for this work and sharing the stage it's at. It's really interesting and fascinating, and more power to you as you move forward. With respect to a degree of this methodological problem, I've wondered how much of the resistance among some conservative members of the US Supreme Court to relying on foreign case law or foreign jurisprudence is also a reflection of their originalist methodology as an interpretive philosophy. You know, to the extent one is an originalist, you would have no interest in foreign countries, just as you have no interest in current thinking within the United States. And I'm not sure that they've quite come out and made that tie explicit in the way in which those conservatives have rejected the use of foreign developments, but it strikes me as related. And then, so that leads me to this question of to what extent there is a methodology like originalism in Brazil or not. And I can imagine things might be quite different in any number of other constitutional democracies that have a constitutional pedigree that has so many more dimensions to it than the US Constitution, just because of its age and sort of initial position, if you will, in the democratic pantheon today. So what's the role of originalism in Brazil, and how does that affect, if at all, the willingness to look at foreign jurisprudence?
Thank you, Professor Höfner. Straight to the point. I remember one phrase from Justice Scalia when I think someone asked, I think it was Norman Dorsen, a professor from NYU, in a debate, in the famous Scalia and Breyer debate. He asked Justice Scalia why he didn't like, let's say, foreign material within constitutional interpretation here in the Supreme Court. He, as a so-called originalist, he said that he is one of the justices in the U.S. Supreme Court that cites more foreign cases, but he only cites cases from England. So he was, right. He was joking, of course, but he was saying, I am citing the cases that we are allowed to cite because our country developed from there. Can use those. It was our law at that time when we transitioned to a republic in 1776, and then when we established our constitution in 1787. And so he was saying that, and he even has a phrase saying that I really don't care about any foreign law because I need to know what the U.S. Constitution is, and in order to know what the U.S. Constitution says and is, I need to look in the U.S. and not abroad. But regarding originalism in Brazil, I think the nice thing here is that in our constitutional convention, in our last constitutional convention in 87 and 88, like 34, 35 years ago, at that time, when we were building our constitution, we looked a lot to the US. So we used what I called here this first basic use of comparative constitutional law. We looked abroad to the US in order to discuss how to structure our legislative branch, our Supreme Court, federalism, separation of powers. So I think we don't have like this idea really well established in Brazil, the idea of originalism. I even have a friend right now who is a PhD student. He's trying to create the idea of a Brazilian originalism based on Scalia, but of course relating to our constitutional convention in 1987 and 1988. But there, since we used a lot the US legal scenario, let's say, or political scenario in our constitutional convention, in all of our constitutional conventions, in 1891 and in all the others, I think it's easier for us to resort to originalism because we have only 30 years of gap, let's say. Here in the US, you have 200 years. Even if you adopt the idea of originalism as the public original public meaning at the time, I know that there are lots of divisions of between originalists, ones that adopt this idea of original public meaning. It's hard to think about original public meaning of something that happened like 250 years ago. It's much easier for us in Brazil to adopt that, in my opinion, of course, because we discussed everything that you guys here discussed 250 years ago, we discussed 30, 35 years ago. Our separation of powers, our ideas of federalism, all the structure of our government. And there's another thing. In our constitution, in our constitution from 1988, we have until today, in 34, 35 years, 130 amendments or something like that, 135. So we are amending our constitution like 4 to 5, even 6 times a year. So it's hard to talk about originalism there in Brazil because we are always changing our constitution. So we are adapting actually our constitution through the time. If you compare, for example, the original constitution in 1988 and the constitution today, 35 years later, it's almost another document, you know. So I always tell this friend of mine who's studying originalism, it's impossible to talk about originalism in Brazil because originalism is what happened yesterday in Brazil. Since we are changing our constitution pretty much every day. But just to go straight to the point, I think here in the US, the problem is way, way bigger because you have this 250 years gap between your constitution and today. Of course, Justice Scalia was joking at the time, but I have to agree with him because he was one of the justices that cited most foreign law, but he was citing Blackstone and stuff like that from England. Right. and if you ask me if I tend to have a liberal or a conservative approach in terms of using foreign law, I'm much more I side much more with the liberals on this side in this case, because I think as long as we have like a methodology for the use of foreign law, it's a good tool, it's a good legal tool to work with. But I don't think in Brazil, in the specific case of Brazil, originalism will be a barrier or something like that for the use of foreign law. Not for us, because as I told before, we are living constitutionalists at the most in Brazil. We are changing our constitution pretty much every year. So it's really hard to talk about originalism, even though we can talk a little bit about the convention's idea of our state, of the structure of federalism and major themes like that, federalism, separation of powers. But in daily cases about our constitution or fundamental rights or something like that, we are changing so much our jurisprudence every year, I would say, that's hard to talk about originalism there.
Thanks.
Thank you, Bruno. And if you allow us, we do have one question. Viola has had her hand up for a while, so maybe we can make this a quick answer. But Viola, would you like to come off mute and ask your question?
Sure, please. Yeah, I just wanna say hi to Viola from OSU.
Hi, Bruno. Thank you so much for your presentation. It is really interesting topic. So quick questions. It is regarding the public acceptance of the decisions. How do the general public perceive the approach used by the Supreme Court? Are they happy with the court's breakthrough or even against it? Thank you.
Thank you. In terms of the use of, I'll try to focus on the use of foreign law. In the legal community, I have to say that just like we don't discuss at all this in Brazil, we just let our Supreme Court cite foreign cases and we are okay with it. So the legal community in Brazil is okay. It's pretty much okay with that. The public in general, I think our decisions today, we have such a divided society, just like the US. We had President Bolsonaro that left off like 2 months, 2 months ago. We have a new president, President Lula now. So we have this progressives and conservatives there as well, changing places. I have to say that I myself, I am pretty okay with the decisions of our Supreme Court, and I think that the problem is, just like here in the US, the court is so intertwined with politics, with like day-to-day politics, with conservatives on one side and liberals on the other side, that it doesn't matter what the court says. Whenever the result is going to one side, the other side is going to say, no, I don't like the Supreme Court or whatever. There was some people talking about impeaching judges there in Brazil because they were deciding cases in such a way or in another way. But the legal academia or the legal community, I have to say, of course, we have lots of people criticizing our Supreme Court, but in general terms, I think the court is going too far in some cases. I think it's a common position for the legal academia to think about that. But thus far, I don't see a big problem in the court regarding the acceptance of their decisions by the public in general. So I think the court has to be a little bit more closed, because we have a problem that we have in Brazil, in my opinion, of course, is that the justices are pretty much every day giving interviews and talking about their decision outside the court. They are in the media pretty much every day. I don't think that's a good strategy for a Supreme Court justice to keep talking about their own decisions after they decide that. So, but in any case, I think the court could do a little better in this kind of strategy. But the public in general, I think it's accepting the court's decision, because even if some errors in the past or even now, I think the court is going in the right direction, I would say. I think it's to summarize everything that we're doing. The legal academia is okay with what the court is doing, and the general public is also okay.
Thank you so much, Bruno. I appreciate that, taking the time for that last answer. So I think with that, we will go ahead and close out the event. Of course, feel free to reach out to Bruno if you have additional questions. Fernando mentioned in the comments that he would love the chance to ask a couple questions as well. So we're happy to make those connections too, if you want to continue the conversation. So I'll just thank Brazil Gateway once again for co-sponsoring here. The Moritz College of Law for their role as well in bringing Bruno in the first place. And thank you, Bruno, for the talk. Everybody have a great evening.
Thank you very much.